in the matter of the Friends of the Antique Cultural Treasures Limited and Secretary of State for the Environment, Food and Rural Affairs.
My Lord, in relation to the overnight work, we have an advance note which is with, as I was done at the Cabinet Office for approval. And once it's got that approval, we'll get that to the court. I think it will be agreed and answer all the questions. The answer to the question my Lord, Lord Justice Singh posed in particular is section 5(7) of the Act as amended, which provides that relevant separation law shall trump the provisions of section 5(1) to 6, and that's a provision inserted by UWAGA. We'll provide the relevant section, but it's agreed between us, I think, that the position is the Charter continues to apply until the end of December. What we've also done to try to speed matters up and save your Lordship's pen is we've reduced to a short note the references to the exports interests, it being in relation to carvings, chunks of ivory. And if I could pass that up, you'll see that Mr. Krishnan has been busy working because the printouts are still warm. Thank you very much. Effectively, what it does is draw together the main strands of both my client's evidence by way of submissions leading up to the bill and the relevant materials relied upon by Mr. Pullen to identify the sorts of items that are said to contribute to the allure of ivory in the Far Eastern markets. Now, we were yesterday with the precautionary principle, and where we got to is that the judge's findings of fact, well, he rejected any direct causation in relation to method 1, paragraph 175, saying that the evidence of the UK domestic market contributing to poaching was tenuous at best. That's paragraph 175, and that aligns directly with what the World Wildlife Fund and Traffic were saying. Tenuous at best is the language of Traffic at D2 48692, and the WWF was saying that any contribution was probably only very small, D1 11151. So those two organisations were basically putting their case on the method 3 basis, the sort of tonal level, the symbolic level, the solidarity level. Equally, the judge...
when you say direct causality, is that between supply and demand or poaching? What is the causality
the domestic,
A and Z?
The operation of the domestic market contributes to demand for fresh ivory. And that's because there was no evidence. I go back to the point I opened on yesterday. There was no evidence of any fresh ivory on the UK domestic market. We'll come back to look at that when we deal with my learned friend's respondent's notice. Where the judge...
I'm sorry, just to be, when you say demand for fresh ivory, we're concerned here with the death of elephants and largely through poaching.
Yes.
So the ultimate causality is between that and the UK market.
And that's what I mean by fresh ivory. I mean poached ivory. Yeah. Because the UK, although there is a market for legal fresh ivory periodically, again, there's no evidence of that coming to the UK, not least because we don't any longer have any carvings houses. The only places in Europe with any carvings houses, I think, are Germany and maybe Italy. They're principally concentrated in China. So there's simply no demand even for legal fresh ivory where it arises. The second point was the findings that you saw yesterday about the uncertain, statistically questionable and impressionistic, often anecdotal evidence supporting the link between export of UK antique ivory and demand for freshly poached illegal ivory. And the judge's findings on that are at 155 and 176. And all of that boils down to evidence that doesn't come close to meeting the Valazza test of a likelihood of real harm. The real harm here is harm in the shape of elephants being illegally poached. Real harm flowing from the operation of the domestic UK market or the domestic export market, the UK export market. And that then links to the point I made yesterday, that there has been no systematic analysis of the operation of either the domestic market or the export market in terms of their potential to contribute through the export of legal antiques to demands for illegal fresh ivory. And that's where the submission I've just handed up goes, because what was very clear is that my clients were saying the demand such as it is in the Far East for fresh ivory is effectively demands for large chunks of ivory, is how they put it. Conspicuous carvings that are wholly or almost wholly obviously made of ivory, because the value is in having ivory per se. It's a way of displaying the fact that you own ivory per se. And if you can't afford a chunky carving, it's bangles and trinkets and matters of that kind. Or as the Prime Minister, when Secretary of State for the Foreign and Commonwealth Office put it, quite memorably, it's ornamental knick-knackery for display in countless homes. That's how we put it. And that is, in our submission, a fair summary of the demand in the Far Eastern markets for ivory per se. It's not for rare objet d'art whose value far exceeds the ivory content. It's for the conspicuous display of chunks of ivory. So the question that was never investigated is to what extent allowing exports from the UK to those markets of antique ivory, valued far in excess of its base content, in any way contributes to the allure, etc.
I'm slightly at a loss at this contrast on the one hand between the rare antique objects you're talking about and what you spent a long time in your introduction talking about yesterday, which were items of little value which would disappear. I mean, you spent quite a lot of time, it seemed to me at the beginning, emphasising that the consequences of the Act would be that the table which had an inlay in or other objects of no great value would, as a consequence of the Act, be destroyed or be lost.
Well, I think
that seemed to be the emphasis, and therefore, but now you're talking about something else, which is the value of small objects of antique value. And what is the relationship between those 2 points?
Well, my lord, the utilitarian objects I was referring to, the kind of magnifying glasses with ivory handles that used to be sold.
Walking sticks, all those things.
Well, no, the walking sticks, with respect to are often high value and culturally significant items that command large prices. And as a crude, very crude indicator, anything that commands a four-figure price, north of £1,000, is the kind of thing that is going to be traded through a reputable antique shop.
Right. The only point I'm making is that at the beginning you were saying that one of the significant effects on which you were relying on the Act was that there were a whole lot of items of interest and value to people. They would lose their value, they would be destroyed and completely go. At that stage, you weren't talking at that stage at all about what you're now talking about, which is small objects of high value of antiquity.
Yes, well,
what is your case there?
My case there is, where do you place the line? I accept there's an issue in relation to that, but the distinction that my clients have always made is between the everyday objects of little value that may be traded on eBay or the internet that command at most a couple of £100, £500 or so.
You talked about something of £2,000.
£2,000, we say, is an object of real substantial value. A beautiful inlay table, perhaps made in a factory in the old-fashioned sense, in the 18th or 19th century, for which there's a market for people who appreciate those types of things, is an object of value and of significance. It may not be of outstanding significance.
Your point was, the point was put to you that there's been 3 years, or would have been 3 years or more, for sales to take place, and your answer was, well, there's a risk reward, or cost value basis for making a decision about whether to do that, and actually nobody's going to do that.
Yes.
Well, how does that apply to these objects of value?
Well, the further away you are from the category of outstanding item, the less economic incentive there is going to be to take adaptive measures, or less rational basis to do so. So the outstanding items, who knows what the value of an outstanding item is? It's going to depend on the nature of the item. You might have an outstanding walking stick. It may be the most beautiful ivory-handled walking stick in the country, and a real object of exceptional skill and beauty. It may only be worth £50,000 compared to the most outstanding Renaissance statue made entirely of ivory, which may command the price in the millions. So the problem with the outstanding categories, it doesn't lead to any necessary correlation in value. We're talking about items that are below that threshold, that are well above the kind of tat or trinket that is traded in a market stall. And anything that commands the interest and investment and effort by people with expertise in whatever their particular field, whether it's walking sticks, whether it's fans, whether it's painting frames, it matters not. Those items are, to those who appreciate them, items of real value, of importance. That's the criterion.
Well, if I can deconstruct it in my own words, there's a certain so there appear to be three categories of
Yes.
that we're talking about. I'm not talking about the unworked ivory. There are three categories we're talking about. They're the items of great value, significant value, pre-1918.
Outstanding.
Outstanding. They're those ones. They're not
Yeah.
affected. Then there's a category of at the other end of the scale, which are of value to people. They're desired objects. They may have been passed down through the family or acquired, but they're of little, what I would describe as monetary value. And you say those are in danger of being lost altogether over time as a result of the Act, as I understand it.
And the reason they're likely to be of little value, my lord, is they're likely to have been mass-produced at their particular time, when ivory was the plastic of its age and was used for handles and all kinds of things. Then there are in between.
Then there are in between a range of items, I think you're saying, of value. And they themselves may vary from things that are of antique value. They're antiques, they may have some considerable value, but they don't fit into the ultra category.
That's right.
Presumably for those, there is still a market, or within the 3 years,
Yes.
they could have been sold. I mean, there's a risk-reward ratio, but they're not. There's no evidence that those are significantly affected, is there?
There is, of course they're significantly affected. Take net skis as an example. There is a large number of net skis, made of ivory, but only a small percentage of that cohort of net skis will conceivably benefit from the outstanding item exemption.
I know. I'm talking about in the middle category. There's a large range within that middle category.
There is a large range.
That's what
yes.
I'm talking about.
I'm so sorry, madam.
And there are some near the top end.
That's right.
And there's some near the bottom end.
That's right.
So they're not a differentiated whole.
No.
They're all different ones.
That's right.
And so I'm just trying to sort of nail down exactly what. So one can't say globally for all of them there's no value left. They're completely deprived of any value. It will depend where they fit in that large category.
Well, if they're in the middle category, or indeed in the bottom category, whatever value they had, whether it's the £2,000 table
Yes.
or the £100,000 net ski, which isn't the most outstanding item in the net ski range, it will lose that value. And the value that will be lost will depend upon the category of item to which it belongs and the market prices hitherto prevailing for that type of item. And that will be variable.
Yes. Well, that's. I just wanted to understand that.
Absolutely.
And so your case is it's sufficient, both that in the lowest category the value may be lost completely, and it's sufficient that you would say a significant number in that middle category will be significantly affected.
Yes, and were one looking at a compensation scheme, it's those types of items that those types of factors that may be looked at to decide how to pitch a compensation scheme and how to approach or whether to approach full market value. It's how many items you possess, what is the extent of the losses sustained, etc. And I accept there will be a range of impacts depending on the nature of the inventory or items you've collected. But the point I was making about the export analysis is there hasn't been any review of what was in fact being exported. And that's highly significant because one thing you've got to work out is whether or not this is going to make any difference to the patterns of export at all. And if it is, in relation to what items and what is significant. And what we can immediately see, the minute you actually start to grapple with the data, is two things. Firstly, how very small the export trade is. And secondly, how very small it is when you strip out that part of it that will continue the Act notwithstanding. And that's because all of the figures have been distorted quite fundamentally by the presence of piano keys, each and every one of which is counted as a separate item. And this is addressed in Mr. Pike's second witness statement, Bundle B, tab 9. And it's paragraphs 6 through to 11. But let me summarise it as follows. An analysis of the export records that my client undertook as best it could for the period 2016 to 2018, so a 3-year period, revealed a total number of exports of 5,476 items, even on itself not a large figure, of which 3,700 odd were piano keys, 67% of the total. That total will be completely unaffected by the ban, because it will fall within the musical instrument exemption. That leaves an annual export number of 900 items. So a UK domestic market, which is roughly estimated to contain about 2 million ivory containing items, is on the judge's analysis, precautionary principle, etc., being banned because of an export of 900 items per annum, combined with factors 3 and 4. What there's been no investigation of is what those 900 items are. Now let's suppose 500 of those items are billiard balls. And you've got my submission. Of course you should ban the export of billiard balls. If they're being recarved, that is an item that may indeed be supporting the demand for knickknackery. Fresh ivory, conspicuous display of items made wholly of ivory. So what is in that 900? And how is it going to be affected by the ban? Are 200 or 100 of the items of outstanding importance, commanding record prices at Christie's or Bonhams or wherever it may be, that have been exported to the new super rich in Asia who've bought some extraordinary piece of Renaissance art made from ivory? You simply don't know. What you do know is that the figure is very small. The very lack of a larger export figure from a market that is supposed to be awash with ivory is itself demonstration of the fact that there is no demand per se for all of the types of items that contain ivory that are present in the UK market. It's a clear pointer towards the fact that if there is any demand in Asia for ivory containing items, it's pretty targeted. So why is it that everything flows from these figures? Why is it that you can make any safe inference as to what's going on? And shouldn't those figures be investigated to see what is in fact being exported, and is it the type of item that might contribute to some kind of allure? Because if, for instance, the figures reveal that there's a Chinese billionaire who's developed a particular taste in inlay furniture, some of which contains ivory, and over the period he's bought 100 items, again, that doesn't do anything to support the thesis that export to China of items containing ivory indicates a demand for ivory per se. It's complete non sequitur. We don't know the answers to any of this beyond piano keys, the only bit that we can investigate, because it's never been looked at. But what doesn't follow is that a demand for export of antique ivory leads inexorably to an inference, a safe inference, that there is a demand for ivory per se, such as to sustain demand for fresh poaching. It's a complete non sequitur. Take the fish knife example I keep on giving. The fish knives are in bundle D1, tab 8, page 113. They're beautiful exemplars of Victorian silver cutlery manufacture that have large ivory handles, large enough to get you over the 10% threshold. But can you assume that simply because an item like that may have been exported, and we don't know if it isn't, if it's no cutlery being exported, it rather suggests cutlery is not a problem category. But if it has been exported, can you assume from its export that that shows a demand for ivory per se? it's, with respect, untenable. And once you approach the absence of evidence in that way, you can see that it can't be saved by a precautionary principle technique of the kind the judge used. It simply doesn't meet the Valazza test of an investigation of the evidence at your disposal using quantitative and qualitative techniques. It doesn't come close to it, and it simply doesn't come close to meeting the threshold of showing a likelihood of real harm. Effectively, what this saving of method 2 has done is presented a gateway to reason the whole case by reference to modes 3 and 4, which then effectively turn the judgment. So, to conclude on the precautionary principle, this evidence doesn't meet either the Valazza threshold, nor, as and when it mutates into mode 3 and solidarity with others, does it meet the Trident threshold, which is all about showing benefits to the relevant protected species, concrete benefits. And the last point, and you have my submissions on this already, none of this is intended to be temporary. It doesn't bear any of the hallmarks of legislate and act on a protective basis until better evidence becomes available. It's all intended to be permanent.
There's a reference, I think, in the IA to a review in 2023.
That's right, I mentioned that. That's right. I hope I fairly...
No, yeah, absolutely you did. What does that mean in policy terms? Is that's not built into the Act, I don't think?
I have no idea. I have no idea what is intended. Perhaps Sir James can answer that question. Because it doesn't seem to have any meaning. I mean, how are you going to turn the clock back? So, topic 3, deference to Parliament. This is a very short topic. The judge dealt with this at paragraph 161 to 164 of his judgment. And the problem is essentially this. The Supreme Court in Lumsden left open the question as to whether or not the identity of the ultimate decision maker made any difference to the intensity of review to be accorded. Lord Carloway, in the Sinclair Collins case, had said, no, it doesn't. It doesn't make any difference at all. The answer of principle as to why it doesn't make any difference at all is because the function of the court, when scrutinising measures that restrict EU free movement in this way, must be the same as the court in Luxembourg when exercising its infraction powers. It would be unprincipled and illogical to adopt a different approach to proportionality to the CJEU in an infraction context, not least because the domestic court is, if anything, better placed to conduct an assessment than the CJEU, better placed in procedure, familiarity with the subject matter, etc. And therefore what you should be doing is proxying what the CJEU does, and as was recognised in Lumsden, there is nothing in the CJEU infraction case law to indicate anywhere any deference to the fact that the decision maker in question is Parliament or the supreme legislative body. All that may be relevant is subject matter. Now, I accept that if the subject matter is truly a moral question, as was ultimately the case in Countryside Alliance, an expression of disgust for deriving pleasure from hunting animals with dogs, then that moral expression, whether it's a moral expression by the executive through delegated legislation, through primary legislation, that indeed does attract deference. And there's plenty of case law in the field of gambling, in the field of cruelty to animals, etc., to demonstrate that that is the approach of the Luxembourg court. There's literally no basis, however, to contend that there is deference paid to the executive, to the legislature, simply because it is the legislature. Now, that position has been left open by the Supreme Court. Our answer is do what the CJEU would do, a submission I could make for the remaining 10 months of the year. That is what the law requires. And the uncomfortable
But
consequence...
the CJEU would grant variable degrees of deference, as it were, perhaps wrapped up in the expression margin of appreciation, depending upon subject matters. So, for example, in the gambling cases,
Absolutely.
they refer to public policy, they refer to morality, and they accord greater deference to the decision maker
Yes.
than, for example, if it was purely economic, was dealing with widgets.
Absolutely, but the judge has been through all the factors that calibrate the CJEU's discretion and the margin of deference it accords, and found correctly that they all indicate a high degree of scrutiny. With one error, the one I addressed yesterday, which is the combined effect of fundamental human rights and free movement of goods, the Festerson, a particularly restrictive measure requiring particularly close scrutiny. So,
Did you say it was high intensity? I think you said it was nuanced, the judge.
well, no, what the judge said I think it's a paragraph. It's 164 is the paragraph I think my Lord's thinking of. He sets out all the factors that suggest it's a high intensity of review. And then, effectively, he undoes that substantially in the balance of the paragraph by saying, because of DEFRA's expertise and because of the particular position of Parliament, that cuts the other way. And it's that step that we say is incorrect. It is a case where the law requires a strict approach to be applied.
Can I ask you about the possible difference between a court like this one
Yes.
and Parliament? One difference that's often suggested is relative institutional competence. Leave aside democratic legitimacy for the moment, but just on institutional competence. For example, there was a long consultation exercise in this case. DEFRA had the opportunity to analyse the consultation responses. A draft bill is introduced. There are committee stages. Amendments are considered. Sometimes they're accepted. As I understand it, the narrowness or breadth of the exceptions to this Act were debated in Parliament in both houses. Now, we conduct a 1.5-day hearing in this court. You show us some bits of the evidence, but we don't have the full picture by any means.
Well, the question that we're grappling with in terms of likelihood of real harm is an evidential question. And as the judge correctly said, it's the kind of question that a court is singularly well equipped to deal with. Courts are specialists in evaluating evidence and forming conclusions in a way that I would suggest parliamentarians don't have necessarily as their core competence. So he was quite right to say that insofar as it was about economic or scientific or other forms of justification, a court is just as well placed. So we support that. Where he parted company was in relation to the political or moral perspective. And by political, he meant the judgmental exercise of saying, if the UK acts, will it encourage others to act? If the UK acts, will it underpin the efforts of others? Now, in relation to the first, I would suggest that that is, if anything, the field of diplomacy. It is not the core competence of Parliament to engage in predictive exercises about how other states will behave. That isn't, with respect, one of Parliament's core areas of expertise.
Are we better placed to assess that?
You're no worse placed, my lord. And if that becomes the core of the argument advanced, then it really is the core, ultimately, of the argument advanced. You have to grapple with it. You have to engage with it by reference to some standard. The problem with the approach urged on you by Sir James is that it's ultimately exiguous. It is ultimately exiguous because it's enough to simply invoke the prospect that there may be some gain somewhere by someone potentially acting in a way that's influenced by the UK. It's an argument that's also advanced without any investigation of the counterfactual. because the counterfactual is not business as was. It's a stricter version of the Act. Yes, we accept that. It's a stricter version of the Act, but with more meaningful and proportionate and human rights compliant exemptions. And that may send exactly the same message, functionally, as this Act, particularly in circumstances where, so far as we can see, just about every other system of law operates a fairly generous exemption for antiques. Look at America, which is prayed and aid time and time again. The exemption in America is a rolling 100-year exemption for antiques. Yes, you have to prove that they're antiques. Yes, there needs to be strict documentation, registration, all of which we urge upon the court as part of the counterfactual. My clients will happily buy into a system that requires the strictest proof that the item is what it says it is, to eliminate forgeries, fraud, the opportunities for fraud. But that's the counterfactual. And it's very important when you look at the alternative regimes not to look in particular provisions in isolation. I had a debate yesterday with my Lord Justice Singh about the 5% threshold. You have to appreciate that a de minimis threshold in the United States works in a very different way to the United Kingdom scheme. Why? Because it operates in a different space. Why? Because there is a rolling 100-year exemption. And so the function of the de minimis exemption in the United States is to pick up the gap between the 100-year exemption, the 50-year-old item that doesn't benefit but has only marginal amounts of ivory, whereas in this country, the de minimis exemption is the only exemption for antique ivory that doesn't fall within Section 2. It's a very different function. It's a very differently calibrated regime. So you can't just simply compare de minimis with de minimis. You have to look at the schemes as a whole. And our submission is, in relation to those political judgments, the court, insofar as they're reviewable, the court is as well placed as Parliament. And I don't shirk from that, because that is the logic of the CJU case law. It may be a position that only holds for 10 months, but that is the law as it presently stands. So that's the third point, the point left open by Sinclair Collis, and with respect we say it makes no difference at all in these circumstances that it's Parliament. The test to be applied is the Trident test, and it's to be applied on a strict basis because of the highly restrictive effects of the measure in question. Topic 4, the respondent's notice. I don't know with what degree of close attention my lords have picked through the respondent's notice, but it's quite significant to just see what it contemplates and what it embraces. It's in Core Bundle 3, Core Bundle 1, tab 3, page 40. There are 4 elements to the respondent's notice. Element 1 and element 2 are challenges to the judge's findings of fact. They say, in effect, there is a sufficiency of evidence to find that there was effectively material harm caused by the UK market, that's point 1. Sufficient evidence to support method 2 without reference to the precautionary principle, that's point 2. And then point 3 is to say, even if we're wrong on all of that, and so even if there is no evidence of any likelihood of any real harm, it's enough that by banning this legitimate, non-harm causing activity, we send a message to the international community to encourage them to act. That's method 3, that's point 3, and point 4 is on the topic of compensation. I'll pick up compensation in my last topic, proportionality strictu sensu. Just want to grapple with the first 3. Why? Because the arguments that the respondent has deployed here are its best case. They've pointed to the facts in the materials before the court that they think most strongly establish the existence of harm. And when you look at their smoking guns, because that's what they have to be, because this is an area where they are challenging factual findings, and therefore have to show the factual findings are plainly wrong. That is the relevant test from Henderson, as we've set out in our supplementary skeleton argument. They come nowhere close to meeting that threshold. Now, they've also cited, or asked to be added to the bundle, the case of Crown R and the Chief Constable of Greater Manchester Police, which is the leading case on the threshold for intervention in a proportionality challenge. And we accept that where you're effectively appealing against the court's proportionality of the assessment of the facts as found, the test there applicable is merely to show that the question, the answer arrived at was wrong or contains an error of principle. There's no adjectival qualification of plainly wrong or significant error of principle. But that, with respect, doesn't help my learned friend in relation to Restore Notice points 1 and 2, because they're all about the facts, not about the judge's approach on the facts. So we're actually grateful for that authority, because it confirms the correctness of our approach in relation to what we say are the legal errors in the judge's analysis. It's a different and stricter approach in relation to factual errors. Now, let's look at the evidence deployed in favour of each of these points. The first thing we should look at is Respondent Skeleton paragraph 34, because this is where the attack on the findings in relation to the domestic market begins. The first point is made that there's a potential, if there's a legal market, to mask illegal products behind lawful products. And they cite a UN paper for that effect. Let's turn that up. It's in D2, tab 33, page 471. And the relevant passage begins at the last two lines of the right-hand column of 142 and goes down to the paragraph starting "the same may be true of services." If I could just ask you to read those three paragraphs, then I'll make my submissions. This has precisely nothing to do with antique ivory. The critical thing to understand is that there have intermittently, and indeed quite regularly in the case of the Far East, been lawful markets for freshly harvested ivory. Indeed, there was a massive controversy about the decision of CITES to allow a very large haul of fresh ivory to be released to the Japanese and Chinese markets in 2008. There's quite a bit of evidence about that. The lawful market that they're referring to is a coexisting market for making fresh products. That's the first point. It's not about antiques. It's not about laundering fresh ivory as antiques. The second point to make is that even on the face of this paper itself, it says that that will be answered by proper regimes of registration and documentation. If the source, last paragraph, of these products were clearly documented internationally, they would not be confronted with this dilemma. In other words, there would be no customer confusion. So that, with respect, proves nothing internationally with which it's concerned. Still less does it address problems in the UK market, which is what Method 1 was all about. So, yes, indeed, as the section says, regulating the licit can curtail the illicit, and we say the appropriate regulation is better registration, proof of age, etc. So that's no good. Back to the skeleton argument, 34.2. they point to various prosecutions. Now, this was extensively considered by the judge. The relevant criminal offences, in every case, concerned improper dealings with pre-convention ivory. You remember at some length, tedious length yesterday, I showed you the provisions that distinguish between antique ivory, for which there is, for domestic internal trade, no requirement to have any form of certification, and pre-convention ivory, which has to be accompanied by a proof of age at all stage to distinguish it from more recent ivory. And the prosecutions in question were in relation to people who were selling pre-convention ivory. None of the prosecutions were for people selling freshly poached ivory. And again, with respect, it's all grist to the mill that there is no evidence to show any problem with fresh ivory in the UK. And equally, the problems in relation to pre-convention ivory are fully answered by the imposition of stricter evidential requirements, registration requirements, etc. And then the last argument, and this is the argument that they run both for the domestic market and the international market, is, well, the smaller the trade, the smaller the lawful trade, the less scope for fraud. But with respect, that argument is a non sequitur in relation to the domestic market, because if there is no detectable fraud in the domestic market and no evidence of a problem, it's addressing a problem that doesn't exist. That's it. That's it for their case for saying the judge was wrong, having fairly investigated the evidence. It doesn't come close to a plainly wrong threshold. It doesn't even come close to a wrong threshold. The judge's finding was obviously right, and the fact that it aligns pretty closely with candid, straightforward submissions from reputable NGOs that there wasn't a problem with the domestic UK market is telling. So what about method 2? The case in relation to method 2 is at paragraph 36. And the paragraphs of the judgment referred to are 79 to 80, which are probably worth reminding oneself of. Page 99 and following, tab 6 of the core bank. So it's 79 through to 94. The judge very closely reviewed all of the evidence. The first point to make in relation to 36.1 is that, as the quotation from the relevant fact sheet in paragraph 79 to 80, which is the target of 36.1, makes plain, that you can find in D123 if you want to look it up. That
The fact sheet.
the fact sheet.
This is set out in paragraph 80.
It is, yes, but the actual fact sheet itself you can find at D123. And that fact sheet makes it plain that all of these data are in relation to transshipments. So nothing to do with exports in the true sense, i.e. an antique shop with a beautiful net ski applying for an export certificate to sell it to a customer in the Far East or the US or something of that kind. They're all to do with things seized in containers or baggage in transit through the UK airports. Completely irrelevant to any contribution of the UK market to problems in smuggling. It will be a problem whether or not there is the Ivory Act. So that one falls away. 36.2 is the allure argument, and this really is the high point of its case. And the first point to make is in relation to the allure argument, is that he has to be put into proper factual perspective. 900 items a year that aren't piano keys, an unknown number of which may continue to be exportable, as against the figures that show that some 600,000 items were imported into China in the years, and let me just get this correct, because the figure is cited in Mr. Pike's witness statement, his second witness statement, in tab 9, paragraph 11. It's the years 2010 to 2015. 600,000 items, about 100,000 items a year. So less than 1%. And as Mr. Pike points out in paragraph 11, those items embrace things such as 6,600 kilograms of tusks exported from Zimbabwe. So when you take into account not just the number of items, which can mislead, obviously, as the piano keys example has demonstrated, when you take into account the volumes of ivory, it's way smaller, because the UK has long banned the export of tusks. So the allure arguments have to be put in a factual context. That's point one. And that may explain why the judge said, perhaps with understatement, that the scale of lawful exports cannot be ignored, but it is not substantial. Paragraph 78. But what you have to look at is that small volume and whether or not it contributes to allure. And the allure arguments are all based on the Gao article that we've summarised in the handout. The Gao article explains quite clearly how the Chinese carving market was resuscitated, and the allure exists in relation to chunks of ivory and pure ivory items. There is no suggestion in the Gao article that items are alluring simply because they contain small items of ivory, or that all items containing ivory are desirable for that reason. And it is self-evidently misplaced, as paragraph 36.2 does, to simply lump all ivory containing items and all antique items containing ivory in the same basket. Indeed, when you go back to look at Mr. Pullen's witness statement, what you get very close to is an erroneous logical syllogism that says the more ivory that is being exported, the greater the allure. Because when you look at the evidence that deals with this topic too, and it's in bundle B10, and it starts at paragraph 55 and following, until one gets to the examination of the Gao article in 62, all of 55 through to 61 is concerned to demonstrate is that there is more and more ivory being exported to the Far East. So the problem is demonstrated by volume alone, and that's simply illogical. His key allure argument is at 62 and 63. He cites the Gao article. Even the passage he cites indicates it's about carvings of pure ivory. And then this is it, really, effectively. This is the totality of the evidence, ultimately, on this ground. It's the inference at 63. Many of these allure factors apply to both antique and freshly carved ivory, as they pertain to the nature of the substance itself rather than the nature of the carving. In economic terms, these two sources of ivory are at least partial substitutes in the Asian markets described here. That argument collapses entirely the minute you accept, as the judge did, that many of the items affected by the ban are valued far above their base value in ivory terms. So what you have is Chinese people investing in ivory as a commodity like gold. How much ivory have you got? And that's being equated with antiques that are worth far more than that base value. It's simply illogical. Now, if that means, perhaps, that you need to investigate whether it's billiard balls being exported, or whether or not the item is an item that may be in a problematic category, fine. That's a proportionate way to proceed. But the idea that a non-outstanding but still highly valuable Renaissance statue or inlaid box with great skill made by a famous craftsman is going to be valued for its ivory is nugatory. It's just simply implausible. 36.3, improving enforcement in foreign markets. If we ban our 1% of beautifully documented, impeccable provenance antiques that come with a sheaf of paperwork as long as your arm, that's going to assist the Chinese in stopping people lying in online auction sites about whether or not something is an antique or not. That proposition only needs to be stated to be seen to be ridiculous. The only solution to problems of misdescription of Chinese origin goods passing off the new as antique, which is a problem in China, is Chinese regulation. And the idea that banning this small input from the UK of well-documented, best exemplars in the field is going to encourage them to do better themselves is a nonsense. So there's nothing here to support the attack on the judge's findings on modes 1 and 2. And that then leaves Respondent's Notice 3, which is, I suggest, where the action's at. And it's where the action's at in terms of the questions that you were putting to me yesterday, in terms of, isn't stigmatisation enough in and of itself? And the problem with this argument, it may have some form of intuitive appeal. The problem is it simply doesn't accord with either the underlying EU law or the underlying essence of the protection offered to property rights or offered to the right of free movement. Because ultimately what is being said is an entirely lawful, unproblematic in itself exercise can be sacrificed in order to show how serious you treat the problem, not posed by it, but posed by a neighbouring unlawful activity. Now that is a striking submission in my submission. I can't think of any human rights or A1P1 case where such an argument has ever been made. Compare and contrast to handguns, no one could contest in a handguns case that ownership of handguns was part of the problem. No one could contest that, no one did. But here it said, even if you're trading between two reputable Netsky collectors, that's part of the problem. And it's part of the problem, even if you can't establish...
Does it depend upon, I'm sorry to interrupt, does it depend upon at what level of abstraction one looks at causality? Assume you're right that intra-UK trade has no causal impact. The argument, I think, is that sort of the international moral dimension will cumulatively have an impact in due course.
Well, the second answer is that...
So there is a causal impact, it's just operating at an entirely different level and in a different way. The
second answer is, what is the international consensus? It's the consensus reached in CITES COP17, which is Authorities Bundle 4, tab 70, it's tab 48. My Norbert likes to turn that up. Page 770 of the numbering at the bottom. What parties are encouraged to do by the CITES Convention is to take all necessary legislative, regulatory and enforcement measures, paragraph 3, in relation to a legal domestic market for ivory that is contributing to poaching. So the relevant question under this convention is whether the UK market is contributing to poaching. And the answer to that, if you're with me on grounds 1 and 2, is that it is not. Not internally, not by export. The markets that may be contributing to poaching are China, Japan, and other Far Eastern markets. And if it's thought that the UK market is contributing to demand in those areas, you have my secondary submission, which is the answer is to close off exports to those markets. Now the judge read this as saying effectively that all legal markets contributed necessarily per se to the illegal trade. It's impossible to read that provision in that way. And the best proof of that is if you go through all of the NGO submissions in relation to the bill, none of them say legal markets must be closed. That's what the CITES COP17 say. They're all formulated by reference to proof of the fact that the UK markets contribute to poaching or illegal trade. That's what they're all directed at establishing, because that is the relevant criterion. And the problem with pure ground 3 is it's abandoned that entirely. It said we're closing legal markets even if they don't contribute to the illegal trade, because it might encourage others who have markets that do themselves to close their markets. So there isn't any form of legitimate aim here. The legitimate aim is that identified in Trident, paragraphs 53 and 58. It's about preventing harm flowing from your market and your market activities. And that argument cannot be sustained, so they switch target. But the minute you switch target and go outside CITES COP17, you're out of the realm of permitted justification, and you are sacrificing a compliant market in order to encourage others to close their non-compliant market. So this reasoning, this ground 3, rightly rejected by the judge, that's why it's a respondent's notice. He didn't go down this line. He accepted you had to show some harm in order to get home. That's why it's a respondent's notice. This argument effectively says no harm is necessary to be proved. And of course, it then, and this is the second answer to my Lord Justice Green's point, it switches into the realms of imponderables. Because when one gets to the level of causation, if this were a private law case, you would immediately reject this argument on the basis that the beneficial effects claimed, or the consequences claimed, were far too remote to be ascertainable. There's so many links in the chains of causation to go through here. What is the demonstration of the benefit in question? It almost becomes, the more theoretical or abstract the argument, the less that is required by way of substantiation. And actually, it should be the other way around. If it's direct causation, you expect evidence. If it becomes indirect causation, then you have to have an even better case to show indirect causation. Otherwise, you don't get home. And you can't improve your position by reaching to arguments of such nebulous character. Because that renders proportionality meaningless. It renders the closely formulated terms of the precautionary principle meaningless. And it means the review that this court is required by law to exercise becomes illusory. There has to be a sufficiently proximate link between the curtailment of the rights and freedoms of my client and the harm that is intended to be addressed by the measure in question.
Analytically, that argument doesn't appear, in fact, to amount to the proposition that there is no legitimate aim.
Well, with respect, my lord, it does, once you accept that the legitimate aim in terms of the international community is captured by the multilateral treaty that is CITES.
All I was going to suggest,
I'm sorry.
Your argument analytically appears to be more focused on the question of whether there's a rational connection between the means chosen and the aim in view.
That is part of it, but I do say there's no legitimate aim because the legitimate aims are the aims identified in terms, in this exact context, in relation to this exact set of instruments in the Trident case. And they don't include this type of conjectural benefit.
Well, you make clear in your skeleton you don't object to a policy which seeks to protect elephants.
No.
That's the broadest possible aim and purpose and objective. You don't object in principle to a ban. What you're saying is that a ban of this nature and extent is disproportionate because it doesn't have sufficiently finely tuned exceptions to cover your clients. That's as I understood your skeleton. You accept for the proportionality components. You're not challenging purpose or
Yes, but-
suitability of a ban. It's more nuanced than that.
But even the respondent concedes this. Look how Mr. Pullen puts it in paragraph 70 of his witness statement, bundle B, tab 10, page 121. Even in relation to this advocacy argument in ground 3, he says the government and parliament judged that the UK could better advocate for such change in individuals' attitudes and countries' policies.
Sorry, Pullen, page?
Page 121 of the bundle, 25 of the witness statement, paragraph 70, under heading 3, that shows you're dealing with method 3. The government and parliament judged that the UK could better advocate for such change in individuals' attitudes and countries' policies by imposing strict restrictions on the ivory trade in the UK. And then this is the critical part, because this is what has been tacitly abandoned given the weakness of the argument. Trade in the UK extending to all items at risk of being valued for their ivory content. In other words, is ivory the primary source of value rather than craftsmanship, antiquity, historical significance? And that's what's moved. That's what the stigmatisation argument risks moving, because it loses the connection between whether or not this is ivory valuation per se, which does fuel the illegal trade, or non-ivory valuation, which is accepted not to fuel the trade. And it's accepted not to fuel the trade in relation to outstanding items. It's accepted not to fuel the trade in relation to musical instruments. It's accepted not to fuel the trade in relation to de minimis items. So there's plainly a borderline being drawn. But the minute you move towards ivory stigmatisation per se, in order to encourage everyone else to adopt stronger law, you have lost that controlling factor, which is a critical factor, it seems to us, in the identification of a legitimate aim. It is a legitimate aim to control ivory that risks being valued for its ivory content. Per se stigmatisation, not a legitimate aim. So that's our response to, effectively, this freestanding argument based on method 3. Method 4, I'll listen with interest to what Sir James says in relation to this. The short answer is, it's very hard to see how it's meaningfully demonstrating solidarity with other member states, or other states like the US, the ones that are most extensively cited, by adopting measures that go far, far beyond the controls operated in those jurisdictions. You've got my basic point that the US scheme is a 100-year rolling antique exemption with a federal de minimis level of 50% and lower state levels. How does it support the US regime to ban antiques that the US would permit to be traded internally, to be imported, to be exported, and which they've adjudged not to create any problems in terms of their compliance with CITES? How does any movement of goods from the US to the UK in anticipation of the US ban, which Mr. Pullen refers to at 79 in his witness statement, prove anything? It may simply be the antiques market relocating to the UK, just like the respondents suggest it should relocate to Paris in response to the ban. It doesn't prove anything in terms of patterns of fresh ivory. There's no suggestion that fresh ivory that would otherwise have gone to the United States is coming to the UK, and if there's no suggestion of that, it's irrelevant. So this solidarity argument really amounts to a hill of beans at the end of the day.
What are we to make of Mr. Pullen's paragraphs 71 and following, in particular 73, where he refers to Australia?
Well,
Apparently the Australians regarded, at least many people there, regarded the UK as a model of best practice. And the committee made recommendations for exemptions in line with the UK model.
I'm afraid, my lord, and I intend no disrespect by saying this, the answer is, so what? If it's flawed by the same underlying misapprehensions and flawed by the same underlying failure to grapple with the legitimacy of aim and causation, the fact that someone else has made the same mistake doesn't advance matters at all. And it's all too tempting. I can immediately see, as a legislature, you have very highly trailed UK legislation, the strictest in the world, the most protective of elephants in the whole world. You can see immediately how many MPs or members of the legislature are going to say, well, we want that too. That's an instinctive reaction. But with respect beyond that, it doesn't go, because it's not as if Mr. Pullen is pointing to the materials generated in Australia to say, what's more, these criticisms have been raised and answered in Australia, and here's a whole bunch of additional data or answers. They just say, well, doing what the UK does. And that doesn't take matters any further. I'm afraid it's a bit of a jury point. It's not an answer on the plane of proportionality.
Can I ask you about the nebulous point?
Yes, ma'am.
I don't know, if you want to come back to it later, that's fine, but I was thinking of, I seem to recall there was a case about a ban in Germany on laser guns.
That's Omega Spielhaben, I think.
Yes.
Yes.
That's the one. So, as I recall, the Court of Justice of the European Union said that that's okay, there's a challenge made to it, including, I think, under Article 36.
Yes.
And they said, and there's no question, as I understand it, that Germany was saying, if you ban these sorts of electronic games, that will stop people being killed in real life. It was more, it was a nebulous value, if you like, of maintaining the dignity of the human being, which is in, I think, the first article of the Basic Law of the Federal Republic.
It was a moral argument.
Yes.
It was a pure moral argument, and the case turned upon the fact that the state legislature had formed a view that it was morally abhorrent to derive entertainment from simulated killing.
Yes.
And that, with respect, is a countryside alliance case.
Yes.
It's not this case.
Well, why is it not this case?
It's not this case because the argument in this case, the justification is, it's morally abhorrent ever to have killed an elephant or to have an item made from an elephant that has been killed. Because if that was the case, the ban would indeed be total. That's not the justification that's ever been put forward. This has all been about stopping current poaching.
But could it be said that it's like this case in this sense, the sort of point that Mr. Pullen's making in this section of his witness statement, that you've got to start somewhere. If you want to achieve an international consensus, you've got to start somewhere. And therefore the UK wants to take a lead. And that's the bit that you say is totally nebulous and not based on evidence. Well, what I'm suggesting to you is that it's bound to be nebulous and not based on evidence. You've got to start somewhere. You then nudge other countries like Australia and they start to follow.
Well, two answers. One is formal and technical. The judge rejected any pure public morality argument, and there's no respondent's notice to suggest he was wrong in so doing. So it's all still, as I understand it, ultimately grounded in an idea of harm. The second answer is that form of morality argument hasn't been identified by the CJEU in Trident as forming a basis of a permitted justification for what is an environmental measure. So the only basis upon which you are competent as a member state to trump the fully harmonised EU regime is for further environmental protection. There is no competence to trump the EU environmental regime for a non-environmental reason. And that's why the public morality argument doesn't get off the ground. It has to be grounded in protection of the environment. Otherwise, it's not a permitted aim for this type of exceptional derogating measure taken under Articles 191 to 193 of the treaty. So that's the answer, my lord. That's why they've never put, as we understand it, the case purely on public morality grounds. It doesn't fly. It's not a permitted argument. So I'll come back to topic 4 in the respondent's notice, the compensation scheme, when I deal with proportionality strictu sensu. But can I just flag this for my Lord Justice Singh? One of the things I am going to be saying about the nebulous argument is that the minute you have failed to anchor your measure in any form of likelihood or proof that the activity being banned or prescribed is harm causing, and you're resorting to the type of nebulous argument that we say underlies this, then the basis for saying that this type of measure can be imposed and without compensation to people whose activity seems to be perfectly harm-free, the case for compensation is compelling in those circumstances. Because what you are saying is, we're taking this lawful, legitimate, non-harm-worthy business and sacrificing it in order to gain chips to persuade our international colleagues to do something in relation to their harm-causing market. And if you're being sacrificed in that way, to the tune of many hundreds of thousands of pounds in some individuals or more, that is anything but a fair balance when one comes to proportionality strictu sensu. So the weaker the argument versus the greater the harm being imposed, the more compelling the case must be that the measure is disproportionate without the payment of fair compensation. My topic 5, my lord, and these ones I'm comfortable I'm going to get through in the remaining 45 minutes I have. Topic 5 is arbitrariness. I'm going to take this pretty quickly because we set out our case very fully, probably think too fully, in paragraphs 70 to 76 of our skeleton argument. The basic problem, the fact that the gown is caught in the seats, the basic problem is the lack of consistency with which these exemptions are drawn. Because the exemptions that are drawn in a recognition that there are categories of item that are valued other than for their ivory content. And equally, they're drawn on the basis that there are some forms of appreciation of ivory items that are non-harm causing, most obviously enjoyment in museums. But once you accept, as the judge did, that many of the items falling in the middle category I explored with the Master of the Rolls are appreciated for their artistry, not their base ivory content. And that is inexorably the case for items like net skis, whose value exceeds many hundreds of times the base ivory value, even at the lowest end. The judge gave an example of a £200 net ski, containing minuscule amounts of ivory, that was worth, therefore, many, many hundreds of multiples of the base ivory content. Once you accept that there is these items valued for their artistry, and no one could sensibly say that net skis aren't cherished because they are beautiful things made by highly skilled carvers in miniature. That's why there's racks of displays of net skis in the Japanese gallery in the Victoria and Albert Museum as exemplars of the finest Japanese carving of the 18th and 19th century. Once you appreciate that, the distinction drawn between portrait miniatures on the one hand, which are exempted, and net skis which are not, become impossible to understand. Now the government's answer to that is to say, well, you can't see the ivory in a portrait miniature, and therefore it's not being valued for its allure per se. But if, as is the case in relation to net skis, and if the evidence shows and the judge accepted, there's no material difference in price between a net ski made of wood or a net ski made of ivory, the thing that makes it important is it's beautiful and carved by this famous carver in Edo in the 19th century. Then the case that you're valuing it for its ivory content is hopeless. And the most of the evidence shows is that collectors of these things want to have a balanced collection, and a balanced collection means having a range of the media used by the particular carver, whether it's tortoise shell, wood, bone, or ivory, or hardwood. But they are not items that are valued for their ivory content per se. And the problem is, therefore, that the Act draws a completely arbitrary distinction between portrait miniatures, which are subject only to a registration obligation, but are otherwise safe, and netskis, which may be worth tens or hundreds of thousands of pounds. I think the recent auction records are in the £200,000-300,000 mark for a single netski. It's an arbitrary distinction. It's simply not consistently applied. And it can't be the case that, for instance, all portrait miniatures are outstanding. They're most certainly not. They were pretty commonplace. Some of them are pretty ordinary as works of art. They were just in vogue, and the ivory was used to connote and bring to mind skin tone, because that's what the underlying ivory enabled the painter to convey. So the distinction is arbitrary. It's the same with musical instruments. The argument's been accepted that musical instruments have values, notwithstanding the chunky amounts of ivory in a keyboard that require the lifting of the de minimis threshold from 10% to 20%. Musical instruments, which are ubiquitous in middle-class households, and often contain ivory if they're beyond a certain age, whether it's clarinets or keyboards or bagpipes, for those of us who have bagpipes, violin bows, etc. Musical instruments aren't valued because of their ivory content. They're valued because of the craftsmanship or skill with which they're made, or the pleasure that they give as a musical instrument. But it's exactly the same with the appreciation of a beautiful table, or a beautiful fan, or some beautiful cutlery, if you're a collector of cutlery, or the collector of firearms with ivory inlays. It's no different. You're not valuing those things because they've got ivory in them. You're valuing them because of the pleasure that they give you, for the artistry and skill with which they're made. And once you start drawing those distinctions, the law requires you to do so consistently. And that's the basic vice of the exemptions. There is no consistency in the treatment of items that are plainly valued way in excess of their ivory value and have no credible case of allure.
So what is it you're saying would be consistent? Are you saying that numerical style exemption would be consistent?
Well, I don't mean, that's my next topic, my lord, least restrictive means, but let me answer you directly. I don't mean to be difficult when I say it's not for me necessarily to say what the exact contours of a more proportionate scheme are, because there are many more proportionate schemes. It's enough for me to say this scheme is patently disproportionate, as it is. Now, as it happens, what we say by way of less restrictive means is possible. First of all, much stricter registration and documentation and proof of age to eliminate any residual prospects of passing off or matters of that kind. All of that is a given. Secondly, investigation of the patterns of trade, and if necessary, restriction on exports of those items to those markets where there is a risk that those items will contribute to allure in those markets. That's a tailored solution, but if it's too finely tailored, you either proceed to a ban by reference to markets, or ultimately, an export ban altogether. Close the market to an internal market. Now, is that more proportionate? Of course it is, because it means Mr. A, who is a collector of netskis in North London, can sell a netski to Mrs. A collector of netskis in Glasgow. And no one could plausibly suggest that that isn't in any way going to give rise to any risk of harm. So, if necessary, that is the ultimate fallback position, an export ban, and it should be temporary. If this is precautionary principle, it should be so long as there exist markets with problems of illegal ivory on their markets. And that's why we think a more proportionate solution would be, for instance, a market-focused approach. You can trade, let's say, with the US, because the US is a clean market. It has no material problems of illegal ivory. And the answer to that point, which is an argument that surfaced, let me be completely candid, through argument and exploration with the judge, the answer to that, given by the respondent, is it would be invidious to blacklist certain markets or to single out certain markets as problematic. And that is an argument. It simply doesn't bear any sensible inspection. Our legislature does that all the time, whether it's in relation to data protection, human rights, asylum, practices of human rights violations. All of the materials flag up, indeed all of the evidence before the case, flag up where the problem markets are. It's all about the Far East. It's all over Mr. Pullen's witness statement. So what is this reluctance to express the truth that every NGO and even the department's own witness knows, which is the problem stems from the Far Eastern markets? Incomprehensible. So how does that present a problem to a territory-based ban? Impossible to understand. But if it was to present any such obstacle, how does it justify not simply imposing a general export ban and allowing a perfectly lawful, perfectly unproblematic domestic market for antiquities to continue unchanged, save for obligations in relation to registration, etc.?
Was that a proposition that was put forward in the course of the passage in Parliament?
It was actually put forward by the WWF, yes. I can show you that submission. It's a D1 tab 10. D1. Oh, sorry, 11, I'm told. It's in very small print. Forgive me. And what I would commend your attention to is, first of all, what's said about de minimis at 13. And then in particular...
Sorry, so we're now looking at D1...
Tab 11.
Tab 11.
This is the WWF response, as you can see, both from the index and from the email address of the person submitting it on the first page. And it's the response to question 18 and 19. They draw a distinction between high cultural value and outstanding cultural value.
Page 386.
That's right, my lord. It's the answers to 18 and 19. And they propose that items that are outstanding should continue to be traded internationally, and items that have high cultural, historical, artistic value should be entitled to be sold only within the UK.
This only applies to items of significant artistic, historic and cultural value.
Yes, so it wouldn't capture the utilitarian items.
But it wouldn't capture the things that also at the bottom end of the middle
Yes.
category.
Yes. But
Capture things nearer the top.
yes, I didn't say it was exactly the same as what I proposed, but it's in substance the same technique being imposed, which is to say, effectively, in recognition of the contents of response 2 on page 150 to 151, that the UK market isn't a market for problems. It's probable that, given the limited evidence of direct involvement of the UK in the illegal ivory trade, that any direct evidence of elephant poaching due to this ban could be very small.
The reason I ask the question is because, taking up the point made by Lord Justice Singh, in a sense, this case acutely shows up the dilemma, if that's what one can call it, between issues which have, at least as well as practical matters, some moral overlay as well to it, and diplomatic issues overlaying it as well, considered in before Parliament considered, and then during the course of Parliament, where after, as it were, the event of Parliament's consideration, the courts are asked to apply what you say is quite a strict test, which is imposed by Luxembourg, irrespective of the fact that the legislature have looked at these matters. And so, in a way, it would be a very odd thing, wouldn't it, if Parliament's conducted this exercise on the basis of a wide consultation and careful consideration, the courts then to say, well, you got it wrong because you didn't apply the right tests?
I understand fully the point my lord's making, but again, I don't mean to be glib when I say that is an unavoidable problem with review of primary legislation. That's an inescapable hallmark, pretty much, of all reviews of primary legislation. And the problem that confronts the court is that's a task which the CJEU, like it or not, and whether or not you think they strike the right balance in terms of judicial activism or judicial deference, they roll their sleeves up and deal with on a daily basis in infraction proceedings.
Well, I can see that in a case, for example, which is a knee-jerk reaction to something like the Dangerous Dogs Act, which is rushed through in a day, as it were, or something similar to that, I can see that. But it must make it much more difficult, mustn't it, for the court's approach, where something like this, which has been the subject of very, very detailed analysis, some of the arguments which you're now putting to us have been rejected, for example. It makes it quite a difficult task, doesn't it, in relation to the balance of the Constitution?
Well, the first thing that the court has to do is to decide what the evidence is and what the permitted justifications are. And what this case has demonstrated, I would suggest, is that we've moved quite a lot from the justifications that are identified in the impact assessment and in the materials. We've moved to a quite different point where the argument now, as you put it to me, my lord, is grounded almost exclusively in public morality and this very high-level judgmental exercise, whereas the justification started by reference to combating the illegal trade, removing the opportunity to pass off illegally poached ivory as legal ivory, and removing the drivers for the illegal trade. And the difficulty then is you're effectively confronting me with a pure moral argument, which I don't think is necessarily the argument that was put before Parliament. And we can't get into that because the minute we do, we're in Article 9 Bill of Rights problems. We can't really properly investigate what reasons Parliament took or did not take into account, because that's forbidden territory constitutionally. So all that we can look at is the precursor material.
The impact assessment, can I just ask what the provenance of that is? As I understand it, please correct me if this is wrong, that's just as you have in other contexts an equality impact assessment. This is it a business impact assessment?
Well, it's wider than that. It's looking at the overall impact of the measure in the affected cohort of people. As it was, they chose to confine it to the impact on businesses, and it's flawed for all the reasons the judge gave, even in that respect.
I follow that, but it's not like, for example, legislation is usually preceded, or often preceded, by a white paper.
Yeah.
But it's not that kind of general sort of proposal paper, is it?
No, it's not. It's much more close to the type of comprehensive analysis that one should expect for a precautionary principle assessment. It's looking at the benefits, calculating and computing the benefits on one hand, and calculating and computing the costs, so that Parliament can go into the exercise eyes wide open as to what the consequences of legislating would do. And that's a further answer with respect to the point the Master of the Rolls put to me. If the materials before Parliament are defective in the way that the judge has identified, such that Parliament hasn't taken into account all the things that are relevant and haven't properly been told about the human and monetary cost of the legislation, that goes a long way to affecting the deference to be paid to Parliament. And one could illustrate that by reference to the Begum and 8 misbehaving cases at tabs 10 and 11 of the bundle. Now, these weren't challenges to primary legislation, but they're statements.
Bundle of authority, which volume?
Bundle 1, my lord.
Whilst we're doing that, can it help us with this? We're being told, I mean, there are a number of Supreme Court judgments which say we shouldn't look at the process by which a decision was arrived at. One looks at the actual ultimate measure in its context. Think of the asbestos claims case on Welsh jurisdiction.
These are all human rights cases.
Yes. Does it matter if, to take your case at its highest, Parliament didn't have the fullest information that it might otherwise have had before it, given that the judge took it into account and came to a view? In a sense, did he wipe the slate clean and say, well, it's of the essence in a proportionality case that I've got to look at the measure in the round in its context? Even if Parliament could have had better information, take that point, given what the RPC has said. Nonetheless, I've now looked at it, and in the round, I think combination of method 2 plus 3 and 4, it just about washes its face.
It matters in two ways, my lord. The first way it matters is if the reasoning is grounded in the precautionary principle, because as I explained yesterday, the precautionary principle is a manner to effectively exercise a discretion where there may be a range of permissible answers. And you've got to go about the decision in a certain way to trigger effectively deference for a response to a risk. And if you don't do that, it just doesn't follow that the court then says, well, we can apply the precautionary principle ex post, which is effectively what the judge has done. So that's the first answer. The second answer is that it impacts on deference notwithstanding, because if the decision maker in question has not properly confronted the issue in question, hasn't taken into account the proper costs and benefits of the measure in question, its limitations, its problems, its limited impact, etc., then the decision in question is entitled to far less deference, because it's not a decision reached on a full understanding of the relevant facts. And that's what emerges from the ain't misbehaving and Begum line of case law, because effectively Lord Hoffman says in Begum is proportionality in the ECHR context is not a procedural challenge. You don't win simply by showing that the decision maker didn't ask themselves the right questions. But he says, at paragraph 31, and this is what's built on in the ain't misbehaving case, if you don't take it into account, it appears, if, he says, in such a case, it appears that such a body has conscientiously paid attention to all human rights considerations, no doubt a challenger's task will be harder. So what is effectively he's saying is conscientious consideration leads to a margin of appreciation, or the forbidden deference word. And then that's picked up in Ain't Misbehaving by Lady Hale and Lord Neuberger. Baroness Hale makes the point at 37, page 1432, that if the local authority hasn't taken into account the human rights context, then this is the approach. The views of the local authority are bound, about halfway down through 37, to carry less weight where the local authority has made no attempt to address that question. And the same is returned to in relation to Lord Neuberger's speech at 91, page 1444, where he cites Lord Hoffman at paragraph 31 I showed you in 68 in Denby for the proposition.
Which paragraph in his judgment?
91, my lord. That where a counsel has properly considered the issue in relation to a particular application, the court is inherently less likely to conclude that the decision ultimately infringes the applicant's rights. So in other words, if you take the decision well, you get more deference. And that's therefore the second answer I give to my Lord Justice Groom. It is relevant. And a skewed impact assessment was rightly found by the judge to be one of the factors that demanded a more intense review. That's what his approach was, and we say he was quite right, and there is no cross appeal in relation to that.
Well, that was sort of my point. The judge, if you were, wiped the slate clean by factoring into his analysis what he perceived as weaknesses in the procedure leading up to the adoption of the Act.
Yes, but the pivot in the judge's case is ultimately the precautionary principle for ground 2, leading as the gateway for ground 3 and 4, which then waters down almost completely the intensity of the review that he's planning to
I'm just wondering really if this is a separate point, or it really is wrapped up in your criticisms of his analysis of method 2 and 3 and 4.
I think it is wrapped up, but I was just answering my Lord's question. I think I'd made that point already. So I was dealing with arbitrariness and explaining how the Act does draw lines between a problematic and unproblematic ivory, and unproblematic ivory items are those that aren't valued for their ivory content. And there's any number of items in the affected cohort that can properly be so described, whose value exceeds many tens or hundreds of multiples the base value of the ivory in question, and that no credible case can be made that they're valued for their ivory. That's particularly the case, I would suspect, for items near the de minimis threshold. So that's our position in relation to arbitrariness. It is suggested in response that member states have a high degree of discretion as to the protection they wish to apply. And that's true to a point. That's a point made by the joint speeches in Lumsden, but it has its limits. And in this case, its limits are set by the requirements, at the very least, to show some form of real harm, to show some form of benefit. It's a limit set by the requirements of consistency, and that is often the function of a discrimination argument. The function of a discrimination argument, or a lack of consistency argument, is to say, if you want to pay the price, you have to pay the full price by treating everyone in similar circumstances equally. You can't do carve-outs for musicians if the logic of the carve-out for musicians or carve-outs for portraiture is a logic that applies to other items that you're prohibiting. You have to pay the full price. So that's a further limit, and the Commission guidance that I showed you also shows that you can't effectively game the test by setting the desired risk to zero. The guidance says in terms you can't aim for a situation of zero risk most of the time because it's impossible to achieve, and that would mean that you could always justify the most exorbitant measures. And let me give you a simple example. You can't say that it's proportionate to punish littering by a life imprisonment sentence by saying that our attribution of the importance of limiting littering and fly tipping to absolutely zero is so great that we think that that is the appropriate punishment, and it's only that that will serve the deterrent effect we require. That sort of approach where you say maximum deference to the state in the degree of protection it offers strips the proportionality stricto sensu test of any meaning at all. And so, yes, of course, the state has to identify the problem, has to identify in principle how it wishes to address it, but that is not an unlimited invitation to devise measures of ever-increasing strictness. It's also suggested in the respondent skeleton argument, paragraph 46, that the logic of our argument is somehow that the only thing would be proportionate. It's a total ban. And that, of course, is not our case. Our case is, as I've just explained, once you begin making exemptions for things that are ivory containing but not valued for their ivory, you have to approach that in a consistent and principled fashion. And the result, therefore, is, take the net ski example, net skis are not valued for their ivory content, even if the ivory in them is conspicuous. There's no bump in value because it's made of ivory, and therefore it should receive exactly the same treatment as a portrait miniature. Topic 6, equally effective measures. We address this in our skeleton at paragraphs 77 to 83. What this case ultimately resolves to, in our submission, given the weakness of the case rejected by the judge in relation to the domestic market, what this ultimately resolves to is the problem posed by foreign markets that have lawful and unlawful ivory present on them. And therefore, we suspect it also resolves to the strength or weakness of respondents' notice ground 3. And we accept that measures of registration and proof of evidence will work principally on the domestic market, though they will support a foreign market, particularly if taken up and used as best practice for the type of evidential requirements required to show that something is in fact an antique. But really, ultimately, This case resolves to how do you address the problem of interaction with those foreign markets where unlawful ivory, recently poached ivory, is present. And you have the submission I made anticipating this to the Master of the Rolls. We say the proper thing to do is to investigate the problem, work out what the problematic ivory containing items are, and to control or, if necessary, ban those items. It's certainly not all antique ivory, and it's certainly not all markets. But if a market or product basis is too granular, our fallback position is that you should ban exports and permit continued domestic trade. That is a far more proportionate approach, and it would be equally effective for all of the objectives. No harm would flow from it. It would show solidarity with the other states that apply such a strict approach, including in particular the United States. Wouldn't undermine anything being done by those international partners. And done in the right way, it would work just as well to convey the seriousness with which the UK treats the problem of poaching. And I come back to the point I made to Lord Justice Green.
But just on that point, this was a point which the judge addressed. This was the Lord Hague point, wasn't it? The high moral ground point. How can you maintain the high moral ground if you are perceived to retain a domestic market?
Yes. But the charge is hypocrisy. That's the language Lord Hague used. It's somehow hypocritical to have a lawful market.
Well, he said it's about perception, whether it's right or wrong. The perception of orders that you can't take the moral high ground if you retain a domestic market. I'm just that was a point which seems to me to go to the point you're making.
Yes,
which the judge
it is,
addressed.
and I was going to address it because the charge of hypocrisy is actually impossible to understand. Because if the hypocrisy is in having an entirely well-regulated, well-documented market for genuine antiques that are valued for their craftsmanship, skill, historical significance, etc., and not for their ivory content, where is the hypocrisy in saying only items of that kind should be traded? There's no hypocrisy. It's just a total non sequitur. And it moves towards a general moral disapproval for any item ever made from ivory. That's the only charge in which a sustained charge of hypocrisy could be made. And that is not the foundational premise of the Act, because if that was the foundational premise of the Act, all ivory would have been banned, whether outstanding or in a musical instrument.
Does that necessarily follow? Why couldn't that be the starting point? And then, having considered carefully representations made by various NGOs and others, made that to some extent saying conflicting things, Parliament then decides to have a narrow set of exceptions.
Well, that takes us back to the argument we've just travailed about what the legitimate aims are in question and what you're seeking to achieve with the legislation.
All I'm suggesting, for the purpose of this argument, is
Yeah.
it doesn't necessarily follow from the fact that Parliament decides to have some exceptions, that it doesn't have that underlying starting point.
Well, I see the point my Lord's making, but the point I'm addressing in relation to least restrictive means is that if the purpose of the measure is to convey a strictness of approach that is to encourage other international parties with problem markets to address their problem markets, that message would be as effectively conveyed by having an extremely tough system on registration. And it's going to be a user pays principle, which is going to eliminate all of the tat that may be on the market, all the utilitarian tools that have no real value. No one's going to pay a registration fee on a user pays basis for a magnifying glass or something of that kind. It's going to winnow out the items of little value, and you're going to be left with a residual cohort of items of real value. That's a far, far stricter regime than prevails at the moment. The number of items that will remain will be carefully documented, evidenced, etc., logged, auditable, etc. That works just as well to convey the seriousness with which the UK is treating the problem. And if it's accompanied by an export ban to those territories where there are problem markets, that in turn conveys how seriously the UK is treating the matter. Because if we say to China or Vietnam, where the carvery shops are, your markets are in a problem state, and for that reason we're imposing an export ban, that signifies that those are the markets that need to shape up and sort out their problem. Just as a human rights report about torture practices does exactly the same thing. And why should this be treated any differently? It's a bizarre way to address problems that other people are operating, rather than to call them out for it and say, your markets are a problem, you just ban your own market. That's not hypocrisy, that's illogicality. So then we come to proportionality strictu sensu, and that's where ultimately all of these points resolve. It's what the judge saw. I think it's pretty plain from his judgment, that when you put everything in the mix together, was ultimately the problematic question. Just step back and look at it in the round. Is it proportionate to visit this level of losses on these few people, on evidence this weak, on an evidential train this nebulous, in circumstances where it looks like you're either saying the harm that their activity causes is nugatory, or doesn't exist at all and doesn't matter? Is that proportionate? And is it proportionate to do it without payment of compensation? To ban a perfectly lawful, unproblematic business conducted domestically, conducted in export with appropriate controls, is that proportionate? Or are you expecting a small number of people to wear an enormous cost for potentially non-existent gains that aren't even predicated on any kind of direct causal link between the items that they own and the harmful events in question?
This isn't of the three categories we discussed. You're not now looking at the lower category. You're looking at items of value now.
Yes, yes, because obviously when one gets to proportionality strictu sensu, the greater your losses, the more valuable your items, the more disproportionate it becomes. So yes, we are. I mean, the proposition is particularly stark if you're a collector with a large amount of valuable net skis that don't count as outstanding, but nevertheless have a large net aggregate value. And so what does the defendant say, the respondent say in response to that? It says...
Just before you get to their response,
yes,
in advancing your positive case, do you rely on any authority for this proposition? This is not a deprivation of property, as compulsory purchase of land or nationalisation of a company would be, where it's well established compensation has to be paid.
yes.
So in a control of use case, what's your best authority that compensation we have to be paid?
The authority is, I think, Chassagne in France, that says the presence or absence of compensation is a factor relevant to the assessment of proportionality. And my lord says this isn't a deprivation case, but it's very, very, very close to that boundary. For an individual, a private collector, there will be underlying residual value in use, precisely because they appreciate and derive pleasure from the items they've collected. But for a business, stripped of value, the items are worthless. What benefit is there in residual possession of stock that you can't sell? Zero. And look at the handguns case as a contrast. That's a control on use on exactly the same logic my Lord Justice Singh has just given me. The handguns case.
You ban possession, use as well as sale.
Handguns can be possessed if they're disarmed, if they're incapable of use, which is why you can collect antique firearms. What's banned is the capacity for using them. That's why there's that market in reactivating, deactivating guns, the illegal market. So residual possession, is, as I understand it, still possible in that area, but it's a pretty illusory distinction if you're a target marksman or an athlete previously competing in handgun competitions or matters of that kind. The fact that you can keep your guns and can't use them is scant consolation, I'd suggest. And that must be true for businesses. So for businesses, we think this either is a deprivation in substance, and it is a test of substance, or it's very, very close to the boundary line. look at the UCAFPO case, which summarises the authority on the hallmarks of the property right. And time again, the courts in this country have said the signal feature of a property right is the alienability of the thing in question, whether it's a fishing quota, a licence to be a doorman, a licence to run a restaurant, or a chattel. And effectively what's been removed is the right not to alienate it, because you can still gift, but to alienate for money.
Yeah, you can have a legacy, for example.
Exactly.
But alienation for payment is that?
Yes. And most property lawyers would say that's the essence of property. That is the essence of the right. And it's particularly the essence of a right if you're a business claimant, because there is no value in property beyond that for a business. So we say that this is a case where the infringement goes to the essence of the right, and it is either a deprivation, in which case the usual case law is triggered, or it's so close that the presence or absence of compensation is a critical factor to the proportionality assessment. Now, what the government says against that is a variety of things. I've got 5 minutes left. I'll deal with those and sit down. The first thing they say is, well, you've had plenty of time. And that argument is addressed in Mr. Pike's witness statement. And as he explains, the ability to export or remove items is only available to those more sophisticated clients and customers with the resources to do so. And it's only an attractive option for the higher value items closer to the outstanding category. And you have the evidence summarised in the Wood-Newton report. I think it's section, it's probably worth turning it up, D2. Wood-Newton report is in D2. It's tab 26, page 10. This is the evidence on pre-ban sales. It's pretty consistent with the evidence in the underlying factual witness statements, where individual witnesses have attested to the same collapse in value. Which page? It's pages 10 to 12 of tab 26. And it shows that the values have collapsed pre-ban by about 9/10 for many items. And obviously, the more uneconomic it is to export, the more that there's going to be a fire sale. So the fewer outside options you have economically in terms of export, the more the collapse in price you're going to experience is. That's just basic economics.
Is this the domestic price has collapsed?
Domestic prices have collapsed. There is no evidence about the impact on international prices. So that's the first point. It's only an
Quite
option.
a mixed picture, isn't it? I mean, 3.3 of the 114 who responded about what they'd sold, 4% thought the prices were higher, 70% thought lower, and 25% about the same.
Yes, that seems counterintuitive, doesn't it? But actually, there's quite a simple explanation for that. Because what's going to happen is that items that benefit from exemptions are going to increase in value. Because the scarcity of these antiques is going to go up. And items that fall within, or plausibly fall within the outstanding category, are going to increase in value. Again, that's basic economics, because what the Act has done is remove supply. So there are going to be massive winners, the people who hold items that may well get through the tests for an outstanding items. They'll become even more singular. They're going to have no competitors, if you like, in a crude analogy. But everything else, its value collapses completely. So it's completely consistent with the market behaving rationally in response to the ban. So that's the first answer. It's scant comfort, and the more modest the value of your thing, the greater the impact will be. There is a problem Mr. Pike's second witness statement describes in terms of uncertainty, because we still don't know what the criteria are for outstanding items, even though they're likely and have proclaimed to be extremely strict. We have the residual possessory rights, which you have my case on. There's really little value in relation to that. And that's it, effectively. That's it in relation to the claim on compensation or proportionality stricto sensu. And so what you have to do is ultimately look at the case in the round and ask yourself the question that the Convention ultimately poses, that EU law poses through Article 17 of the Charter. Is this a fair balance? Is this a fair solution where massive losses are being visited on a small number of people for marginal gains without compensation?
Forgive me, Mr. Lemmer. I thought Mr. Pullen also advanced another argument to the effect that a workable scheme hadn't been put forward.
A workable scheme of compensation?
Yes.
Well, the answer to that is that there are many schemes of compensation, but the first thing you have to do is indicate that you're going to compensate. And as my lord well knows, everything from the mink fur farming compensation scheme, which was at issue in Kelso, which is in the bundle, where mink fur farming was banned, a compensation scheme for mink fur farmers was introduced. It led to litigation about the amounts being paid. It was a scheme devised by statutory instrument. There was a scheme in the firearms bans. There have been plenty of these schemes. The idea that a scheme can't be devised that doesn't strike the balance the Convention permits to be drawn between full market value, which is the starting point, and some form of discount by reference to the other factors that may be legitimately taken into account, is not comprehensible with respect. Owners of items of modest value in the hundreds of pounds probably shouldn't expect compensation. And that may, if you go for full compensation for everything, be unworkable and financially too burdensome. And that's the kind of thing the government can exercise discretion in relation to.
I couldn't find any evidence of what other member states or states generally do. Is there any other compensation scheme operated worldwide?
No one else has banned antique ivory. So,
Well, but there's bans all over the place.
in relation to what then?
Ivory.
Yes,
Different
but
types of bans, but there's no compensation. I know this is much more particular, but there are no compensation schemes generally adopted.
in relation to what type of ivory ban? I'm sorry, my lord.
But any form of ivory ban. Are you aware of any compensation scheme at all for anything in this area?
For instance, carvers whose businesses are curtailed by no longer being entitled to carve fresh ivory or something of that kind. I'm not aware of any such scheme. Unless I can assist any further.
Yeah, I'm extremely grateful to you. Thank you very much. Now, to some extent, it's a matter of you, Mr. Eady. It seems to me that 4 hours is a long time to concentrate, and I would have thought that a 5-minute break might benefit everybody. A 5-minute break.
I'll try.
Beating my tax into a very stiff on street. Yeah. I'm needing that Christmas gift.